Hi, and welcome to this latest immigration law update video. In this short video, I want to look at the latest Court of Appeal case, looking at the unduly harsh test in the deportation provisions. And in this case, the Court of Appeal uphold a finding by the first tier tribunal and the upper tribunal that the deportation of the appellant would not be unduly harsh on his family. So this is an example of when deportation would not be unduly harsh. This case doesn't establish any new principles of law, but it's a good summary of the where we are at the moment in the state of the law and a good illustration of the application of the law to the facts. So let's have a look at this case. It's TD Albania 2021 EWCA Civ 619. And the judgment is given by Lord Justice Peter Jackson. Now, just to be aware, Lord Justice Peter Jackson gave the second judgment in the HA Iraq case, which is the very significant case from last year, 2020, which gave substantial guidance on the deportation provisions. So this was an Albanian national, aged 34, arrived in the UK 2002, asylum refused, 2011 granted ILR. I presume that was a legacy grant. 2006 met his British partner, 3 British children born 2008, 2009, 2012. He was a persistent offender and he came within the deportation rules because he was a persistent offender. His offending is summarised at paragraph 3 of the judgment. His last offence at that time was June 2018, a sentence of 8 months, dangerous driving, driving whilst disqualified, no insurance, and failing to stop. So a deportation decision was made and the Secretary of State refused his human rights claim on the 18th of February 2019. So foreign criminal is defined in section 117D2 of the 2002 Act. And then section 117C, we have the various provisions that apply in deportation cases, except exception 1, which is the private life, exception 2, which is the family life with the unduly harsh test, and then 117C6, which is the test if you can't meet the exceptions or if you've got a period of imprisonment of 4 years or more, that there be very compelling circumstances over and above. So the FTT made a decision, Judge Lodge, on the 18th of June 2019, and he found it would be unduly harsh for the children to live in Albania because of their ages. They've lived all their lives in the United Kingdom, British citizens, do not speak, and their mother does not speak Albanian, and no experience the Albanian school system. The judge then went on to look at whether it would be unduly harsh for dad to be deported and the children and wife to remain in the United Kingdom. So he says at paragraph 33, returning to the impact on the children, I am satisfied that the impact will be significant, particularly on the 2 eldest children. I'm equally satisfied that family life in any real sense will not be able to continue through modern means of communication. The appellant is the breadwinner and the family will lose their breadwinner. Their mother will be thrown back onto benefits. I cannot but find that it is in the best interest of the children that the appellant remains part of the family in the UK. That, however, is not the critical issue and neither can it be a trump card. We'll come back to that now because these findings formed the basis to the appeal to the Court of Appeal. I've given this matter anxious consideration. I am not satisfied that it'll be unduly harsh for the children to remain in the UK if the appellant is deported. The judge went on to consider 117C6 and found that there were no very compelling circumstances over and above. There was an appeal to the upper tribunal, and upper tribunal Judge Plimmer upheld the judge's decision. I'm not going to go through her reasoning. Permission was granted to the Court of Appeal. The matter was initially stayed pending HA Iraq in the Court of Appeal, but then permission was granted. Interestingly, paragraph 19, the Secretary of State has sought permission to appeal to the Supreme Court in HA Iraq, and the Secretary of State wanted this case stayed pending that application being determined by the Supreme Court, but that was refused. Lord Justice Peter Jackson then summarises the relevant case law on undue harshness. So we have paragraph 23 and the test set out in KO Nigeria, and Lord Carnwell saying it assumes that there is a due level of harshness, that is a level which may be acceptable or justifiable in the relevant context, and duly implies something going beyond that level. Then we have a summary or some quotes from the judgment of Lord Justice Underhill, or the Vice President of the Civil Division, given the lead judgment in HA Iraq, summarising the approach and criticising this, looking for something out of the ordinary. And that was the error, effectively, that the tribunal had fallen into in those appeals. And actually, there's a helpful summary by Lord Justice Peter Jackson at paragraph 22. He says this: the decision in HA Iraq does no more than explain that what is required is a case-specific approach in which the decision maker addresses the reality of the child's situation and fairly balances the justification for deportation and its consequences. It warns of the danger of substituting for the statutory test a generalized comparison between the child's situation and a baseline of notional ordinariness. So it's this wrong approach of saying there's nothing out of the ordinary and having a comparator to the ordinary child. It affirms that this is not what KO properly understood requires. Lord Justice Peter Jackson also summarises the case law on very compelling circumstances. The test is still that in NA Pakistan back from 2016 and Lord Justice Jackson. And it's a collective considerations of all matters relied upon and looking whether they're sufficiently compelling to outweigh the high public interest in deportation. Lord Justice Peter Jackson also looks at the Unani case from the European Court of Human Rights. In that case, the European Court found that the test, the very compelling circumstances test, was a proper proportionality assessment, and you weigh into account all the Strasbourg factors as set out, look at paragraph 25, in the cases of Boltif and Unna, etc. So the arguments were made in this appeal that there was effectively only one answer, paragraph 26, to the question whether it was unduly harsh, and that was to find that it was unduly harsh on the basis and that the threshold had been crossed by the finding that deportation would effectively terminate family life. There was also the additional factor of being thrown back onto welfare benefits, and the FTT had set the test too high, not properly explored the evidence, and also in terms of very compelling circumstances and not taken all relevant factors into account. It's interesting, initially the Secretary of State tried to argue that HA Iraq was wrongly decided, but the Court of Appeal quickly shut that down because that was not open to the Secretary of State on this appeal. There was some further evidence submitted, a further statement, because the children had now been informed of dad's pending deportation and it caused them great distress. There was also evidence the appellants had 2 further sentences of imprisonment. However, these matters did not make a significant difference to the outcome of this case. Lord Justice Peter Jackson, at paragraph 34, starts his conclusions by finding he doesn't find there's any errors of law, that the FTT carried out a careful and balanced evaluation of all the important factors and reached a rational conclusion. It rightly gave significant weight to the interests of the children, but it was entitled to find the public interest in the deportation of the appellant should predominate, and that the effect of the deportation on the children would not be unduly harsh. This was arrived at after a specific and clear-eyed assessment of the evidence and not by a process of generalization. As such, it accords with the approach that has been laid down in KO and HA and described in Unani. So it's this specific and clear-eyed assessment of the actual effects on this family, these children, that wife, rather than a process of generalization and this notional comparator, which was the problem in HA Iraq. At paragraph 35, he also says he rejects the submission that the FTT was bound to reach a different conclusion because of the loss of the family life and the absence of a breadwinner. So that just because the FTT made those findings, it didn't mean that it was bound then to find that deportation was unduly harsh. These are hard consequences for this family, but the tribunals did not err in finding that they were justified by the public interest in deportation of foreign criminals, which it rightly described as very significant. So we must remember this is still a very high test, which not to be conflated with the very compelling circumstances. And that was the problem in HA Iraq, but it's still a high test. And you're still going to need this specific evidence showing the impact on this particular family. They also find that there is no error when considering very compelling circumstances. The judge did prematurely bring the nature of the appellant's offending into account, because obviously offending and the public interest is not something to be balanced when applying the unduly harsh test. That's something that was said in KO Nigeria. It's looking at the undue harshness is the effect on the child or the wife alone. But when you then come to look at very compelling circumstances, that's when you weigh in the criminality. But the Court of Appeal find that the judge properly weighed that in the balance and had those things in mind and reached a sustainable conclusion. So as I said at the start, this case doesn't establish any new sort of principles of law, but usefully summarizes them, and we see them in their application, and it's a helpful pointer of the sort of evidence you need in order to get an unduly harsh finding. So I hope that's helpful. I'll put all the links below this video.